Laguna Lake Development Authority VCA. Facts: RA 4850 was enacted creating the Laguna Lake Development Authority. This agency was supposed to accelerate the development and balanced growth of the Laguna Lake area and the surrounding provinces, cities, and towns, in the Act. Within the context of the national and regional plans and policies for social and economic development. PD 813 amended certain sections RA 4850 because of the concern for the rapid expansion of metropolitan Manila, the suburbs, and the lakeshore towns of Laguna de Bay. Combined with current and prospective uses of the lake for municipal industrial water supply, irrigation, fisheries, and the like. To effectively perform the role of the authority under RA 4850, the Chief Executive issued EO 927 further defined and enlarged the functions and powers of the authority and named and enumerated the towns, cities and provinces encompassed by the term Laguna de Bay region. Also, pertinent to the issues in this case are the following provisions of EO 927 which include in particular the sharing of fees. Sector 2. XXX The authority shall have exclusive jurisdiction to issue permit for the use of all surface water for any projects or activities in or affecting the said region including navigation, construction, and operation of fish pens, fish enclosures, fish corrals and the like. SEC 3. Collection of fees. The authority is hereby empowered to collect fees for the use of the lake water and its tributaries for all beneficial purposes including but not limited to fisheries, recreation, municipal, industrial, agricultural, navigation, irrigation, and waste disposal purpose, provided that the rates of the fees to be collected, and the sharing with other government agencies and political subdivisions, if necessary, shall be subject to the approval of the President of the Philippines upon recommendation of the authority's board, except fish pen fee, which will be shared in the following manner. 20% of the fee shall go to the lakeshore local governments, 5% shall go to the Project Development Fund which shall be administered by a council and the remaining 75% shall constitute the share of LLDA. However, after the implementation within the 3-year period of the Laguna Lake Fishery Zoning and Management Plan, the sharing will be modified as follows: 35% of the fish pen fee goes to the lakeshore local governments, 5% goes to the Project Development Fund and the remaining 60% shall be retained by LLDA, provided, however, that the share of LLDA shall form part of its corporate funds and shall not be remitted to the National Treasury as an exception to the provisions of Presidential Decree No. 1234. Then came Republic Act No. 7160. The municipalities in the Laguna Lake region interpreted the provisions of this law to mean that the newly passed law gave municipal governments the exclusive jurisdiction to issue fishing privileges within their municipal waters. Because RA 7160 provides. Sector 149. Fishery rentals, fees and charges. Municipalities shall have the exclusive authority to grant fishery privileges in the municipal waters and impose rental fees or charges therefore in accordance with the provisions of this section. Municipal governments thereupon assumed the authority to issue fishing privileges and fish pen permits. Big fish pen operators took advantage of the occasion to establish fish pens and fish cages to the consternation of the authority. Unregulated fish pens and fish cages occupied almost one-third the entire lake water surface area, increasing the occupation drastically from 7,000 ha in 1990 to almost 21,000 ha in 1995. The mayor's permit to construct fish pens and fish cages were all undertaken in violation of the policies adopted by the authority on fish pen zoning and the Laguna Lake carrying capacity. In view of the foregoing circumstances, the authority served notice to the general public that 1. All fish pens, fish cages and other aquaculture structures in the Laguna de Bay region, which were not registered or to which no application for registration and/or permit has been filed with Laguna Lake Development Authority as of March 31st, 1993 are hereby declared outrightly as illegal. 2. All fish pens, fish cages and other aquaculture structures so declared as illegal shall be subject to demolition, which shall be undertaken by the Presidential Task Force for Illegal Fish Pen and Illegal Fishing. 3. Owners of fish pens, fish cages and other aquaculture structures declared as illegal shall, without prejudice to demolition of their structures, be criminally charged in accordance with Section 39A of Republic Act 4850 as amended by PD 813 for violation of the same laws. Violations of these laws carries a penalty of imprisonment of not exceeding 3 years or a fine not exceeding 5,000 pesos or both at the discretion of the court. All operators of fish pens, fish cages and other aquaculture structures declared as illegal in accordance with the foregoing notice shall have 1 month on or before October 27, 1993 to show cause before the LLDA why their said fish pens, fish cages and other aquaculture structures should not be demolished/dismantled. 1 month thereafter, the authorities sent notices to the concerned owners of the illegally constructed fish pens, fish cages and other aquaculture structures advising them to dismantle their respective structures within 10 days from receipt thereof, otherwise, demolition shall be effected. The fish pen owners filed injunction cases against the LLDA. The LLDA filed motions to dismiss the cases against it on jurisdictional grounds. The motions to dismiss were denied. Meanwhile, TRO/writs of preliminary mandatory injunction were issued enjoining the LLDA from demolishing the fish pens and similar structures in question. Hence, the present petition for certiorari, prohibition, and injunction. The CA dismissed the LLDA's consolidated petitions. It ruled that LLDA is not among those quasi-judicial agencies of government appealable only to the Court of Appeals. The LLDA Charter does vest LLDA with quasi-judicial functions insofar as fish pens are concerned. The provisions of the LLDA Charter insofar as fishing privileges in Laguna de Bay are concerned had been repealed by the Local Government Code of 1991, in view of the aforesaid repeal. The power to grant permits devolved to respective local government units concerned. Issue which agency of the government, the LLDA or the towns and municipalities comprising the region, should exercise jurisdiction over the Laguna Lake and its environs insofar as the issuance of permits for fishery privileges is concerned. Held LLDA Ratio, Section 4 of RA 4850, the provisions of PD 813, and Section 2 of EO 927. Specifically provide that the LLDA shall have exclusive jurisdiction to issue permits for the use or all surface water for any projects or activities in or affecting the said region, including navigation, construction, and operation of fish pens, fish enclosures, fish corrals and the like. On the other hand, RA 7160 has granted to the municipalities the exclusive authority to grant fishery privileges in municipal waters. The Sangguniang Bayan may grant fishery privileges to erect fish corrals, oyster, mussels or other aquatic beds or bangus fry area within a definite zone of the municipal waters. The provisions of RA 7160 do not necessarily repeal the laws creating the LLDA and granting the latter water rights authority over Laguna de Bay and the Lake region. The Local Government Code of 1991 does not contain any express provision which categorically expressly repeal the charter of the authority. It has to be conceded that there was no intent on the part of the legislature to repeal Republic Act No. 4850 and its amendments. The repeal of laws should be made clear and expressed. It has to be conceded that the charter of the LLDA constitutes a special law. RA 7160 is a general law. It is basic in statutory construction that the enactment of a later legislation which is a general law cannot be construed to have repealed a special law. It is a well-settled rule in this jurisdiction that a special statute, provided for a particular case or class of cases, is not repealed by a subsequent statute, general in its terms, provisions, and application. unless the intent to repeal or alter is manifest, although the terms of the general law are broad enough to include the cases embraced in the special law. Where there is a conflict between a general law and a special statute, the special statute should prevail since it evinces the legislative intent more clearly than the general statute. The special law is to be taken as an exception to the general law in the absence of special circumstances forcing a contrary conclusion. This is because implied repeals are not favored in as much as possible, given to all enactments of the legislature. A special law cannot be repealed, amended, or altered by a subsequent general law by mere implication. Considering the reasons behind the establishment of the authority, which are environmental protection, navigational safety, and sustainable development, there is every indication that the legislative intent is for the authority to proceed with its mission. We are on all fours with the manifestation of LLDA that Laguna de Bay, like any other single body of water, has its own unique natural ecosystem. The 900 km lake surface water, the 8 major river tributaries and several other smaller rivers that drain into the lake, the 2,920 square kilometers basin or watershed transcending the boundaries of Laguna and Rizal provinces, constitute one integrated delicate natural ecosystem that needs to be protected with uniform set of policies, if we are to be serious in our aims of attaining sustainable development. This is an inexhaustible natural resource, a very limited one which requires judicious management and optimal utilization to ensure renewability and preserve its ecological integrity and balance. Managing the lake resources would mean the implementation of a national policy geared towards the protection, conservation, balanced growth and sustainable development of the region with due regard to the intergenerational use of its resources by the inhabitants in this part of the earth. The authors of Republic Act 4850 have foreseen this need when they passed this LLDA law, the special law designed to govern the management of our Laguna de Bay lake resources. Laguna de Bay therefore cannot be subjected to fragmented concepts of management policies where lakeshore local government units exercise exclusive dominion over specific portions of the lake water. The implementation of a cohesive and integrated lake water resource management policy, therefore, is necessary to conserve, protect, and sustainably develop Laguna de Bay. The power of the LGUs to issue fishing privileges was clearly granted for revenue purposes. This is evident from the fact that Section 149 of the new Local Government Code empowering local governments to issue fishing permits is embodied in Chapter 2, Book 2, of Republic Act No. 7160 under the heading, Specific Provisions on the Taxing and Other Revenue-Raising Power of LGUs. On the other hand, the power of the authority to grant permits for fish pens, fish cages and other aquaculture structures is for the purpose of effectively regulating and monitoring activities in the Laguna de Bay region and for lake quality control and management. 6. It does partake of the nature of police power, which is the most pervasive, the least limitable and the most demanding of all state powers, including the power of taxation. Accordingly, the charter of the authority which embodies a valid exercise of police power should prevail over the Local Government Code of 1991 on matters affecting Laguna de Bay. There should be no quarrel over permit fees for fish pens, fish cages and other aquaculture structures in the Laguna de Bay area. Section 3 of Executive Order No. 927 provides for the proper sharing of fees collected. In respect to the question as to whether the authority is a quasi-judicial agency or not, it is our holding that, considering the provisions of Section 4 of Republic Act No. 4850 and Section 4 of Executive Order No. 927, Series of 1983, and the ruling of this court in Laguna Lake Development Authority vs. Court of Appeals, there is no question that the authority has express powers as a regulatory quasi-judicial body in respect to pollution cases, with authority to issue a cease-and-desist order and on matters affecting the construction of illegal fish pens, fish cages and other aquaculture structures in Laguna de Bay. The authority's pretense, however, that it is co-equal to the regional trial courts such that all actions against it may only be instituted before the Court of Appeals cannot be sustained. On actions necessitating the resolution of legal questions affecting the powers of the authority as provided for in its charter, the regional trial courts have jurisdiction. In view of the foregoing, this court holds that Section 149 of RA 7160, otherwise known as the Local Government Code of 1991, has not repealed the provisions of the Charter of the LLDA, Republic Act No. 4850, as amended. Thus, the authority has the exclusive jurisdiction to issue permits for the enjoyment of fishery privileges in Laguna de Bay to the exclusion of municipalities situated therein and the authority to exercise such powers as are by its charter vested on it.